Assalamualaikum warahmatullahi wabarakatuh. My name is Farid Mefarhan 256338, and today I would like to speak about two factors. The first one is mitigating factors and second one is aggravating factors. But first and foremost, I would like to speak about the mitigating factors firstly. What is mitigating factors? Basically, mitigating factors is any information or evidence presented to the court regarding the defendant or the circumstances of the crime that might result in the reduced charges or lesser sentence. So the first one I would like to speak about is the age of the offender. It has to be noted that any underage offender should be sent to the approved schools such as Henry Gurney for the benefit of himself and also the community. This particular matter can be proven in the case of Tukiran Taib against PP. Regardless, the aim of punishment and gravity of offence are given much more priority in comparison towards the offender's age. So basically, the court will look upon the punishment and also the gravity of the offence. In the case of PP against T.A. Cheng, even an 18-year-old boy was sentenced to a 3 years imprisonment for each charge of possession of firearms and of ammunition. So in this matter, it shows that the age does not really exclude the offender from being punished with a severe sentence. The next one that I would like to speak about is the record of offender. In the case of PP against Mark Coding, being a first-time offender has a strong mitigating factor and the accused was released on a good behavior bond. So basically, the record of the person, if you have never been convicted towards any offense or whatnot, and somehow you commit an offense, perhaps that would be one of your mitigating factor to get lesser in terms of the sentence. So in the case of Abdul Karim against Regina, a sentence of 3 months imprisonment was substituted to a fine of Rm 400 as the accused was a first-time offender. I have to mention that clean record is not a powerful factor to lessen the punishment. For instance, the offence of culpable homicide as well as the offence under Section 39B of Dangerous Drugs Act. The third factor that I would like to mention is the plea of guilty. In the case of Sao Soo Kim against PP, plea of guilty is a strong mitigating factor. However, it is contrary towards the case of public prosecutor against Syaritan anak lelaki Pachimutu. A plea of guilty does not automatically take away the discretion of any court to impose the maximum sentence provided for the said offence. Fourthly is the gap principle. So in the case of Zaidun Sharif against public prosecutor, the previous offence of a man was disregarded and he was treated as a man with good character. So whatever happened in the past, it is forgotten. So in the case of Regina against Goodwill and Wilkinson, the period of honest work between the termination of offence and current conviction should be taken into account. So in the case of Su Sainatan against PP, it is mentioned that the gap between the previous conviction and the present offence should be viewed as a mitigating factor. The longer the gap of period, the greater the mitigating factor. Fifthly is the circumstances before commission of an offence. So there are three elements in this matter. So the first one is drunkenness. So in the case of Raja Izzuddin Shah against public prosecutor, the accused was drunk when he slapped the police officer. So High Court ordered the sentence of 3 years imprisonment to be substituted with a bond of good behaviour as well as compensation to the victim. And second element is consent. Consent? In the case of PP against Selva Raja, the girl victim had asked for trouble when she agreed to pass the night with the accused at the rest house and only reported the rape after 3.5 years. So basically, the moment that he agreed to pass the night with the accused is also giving her consent towards the accused, as well as she reported such case after a few years later. That means it shows that she didn't take the matter seriously. Now, the third element that I would like to mention is the provocation. It may be raised as a defense to a murder. So in the case of PP against Ahmad Khairul Faiz bin Mat Dahlan and others, the offender was imposed with 14 years of imprisonment for an offence under Section 304 of Penal Code, considering that the provocation is the act of others that cause the offender to retaliate and commit the crimes. And second one is must balance the degree and nature of provocation against the acts of the accused. So the third one is the accused had a chance of cooling period. The accused, whether in the court have to look whether is there any existence of cooling period between the act of provocation as well as the retaliation of the offender. Next one is the manner and circumstances which the accused committed the offense. So how is the offense being conducted by the offender, by the accused? And the fifth point I would like to mention today is public interest and safety against the individual interest and plea of guilty. So the court will have to look the public interest, whether the act would affect a lot of people around him, or it is just for the sake of the offender's interest only, like between one person to another. Now we move into the sixth factor for mitigating factor. So there will be three classification under this conduct of offender. So the first one, we speak about the repentance. Apart from pleading drunkenness, as I mentioned beforehand, the accused also showed that he was repentant and remorseful for his act. Alright. And second classification is cooperation with the police. In the case of PP against Mahan Tiran, anak lelaki Durasami, the accused was ready with doing cooperation with the police. Therefore, the court should assume that it should be accorded some mitigating value. There will be mitigating value in that matter. And the third classification is the payment of compensation. Again, in the case of Raja Izzuddin Shah against PP, the order to pay compensation to the victim could be one of the mitigating factors in reducing his sentence from 3 years imprisonment to a good behavior bond. Therefore, these three classifications fall under the conduct of offender. So, the conduct of the offender, the behavior of the offender also play a very huge role in this mitigating factor. Now we move into the seventh part of the mitigating factor, the effects of conviction and sentence towards the offender. So there will be two effects here, which is the first one is the effect on the family of offender. The second one is the effect on job and other privileges. So when we look upon the case of Chan Sit Hong against public prosecutor, it is mentioned that before sentencing, the court must consider the consequences towards the hardship of the offender's family. Perhaps he is the breadwinner. If such an offense being imposed to him and he cannot work, might as well it will be detrimental towards the family. Second part is the effect on the job and other privileges. So the court have to consider the position, the reputation of the offender, whether it may negatively affect him or her in the future. So this can be proven in the case of public prosecutor against Vijaya Raj. So a headmaster was found guilty for misappropriation of money. The court found that 1 day imprisonment with 2,400 ringgit is sufficient enough for a person with that high position. Perhaps his position is very important towards other people, towards the community, because he is the headmaster. Now we look at the seventh factor, which is the other factors. So there will be 5 classifications in these other factors. So the first one that I would like to mention is the possession and weight of the drugs. So now we have to look upon So now the court may mitigate the sentences by taking into consideration the background of the offender as well as the quantity of the drugs. Perhaps the higher quantity of the drugs might lead to a heavier sentences. Now, second one is drug addiction. Sentence can be mitigated considering the level of addiction towards the drug. For instance, first offender and the amount of drugs recovered. And now the third one is the less dangerous drugs. The court can reduce the sentence taken into account the types of the drugs, whether it is harmful towards an individual or not. So this is where the court might have to look upon the degree of harm which can be resulted towards the consumption of the drugs, the duration of custody. So the court will also consider the period of the accused where he was held in custody before the trial. The last part is the gravity of the offense that had been committed by the offender. So now, in the case of Muhammad Abdullah Ang Swee Kang against public prosecutor, it shows that in assessing the length of the custodial sentence, the court must look at the overall picture of the offense. First, the gravity of the offense. Second one is the facts in the commission of the offense. Thirdly, is there any absence of mitigating factor? Fourthly, the sentence that have been imposed in the past for similar offense. Therefore, I guess that's all from me on part of the mitigating factors. Now, we're looking at the aggravating factors which can be proposed by the prosecution in order for the offender to have a heavier sentence imposed upon them. So there will be 5 in total today. So now let's speak about the use of force. When force or violence is used to commit the offense, usually a very heavy sentence and whipping will be imposed. This can be proven in the case of public prosecutor against Safian bin Abdullah and another. Second one is the mode of committing the offense. So if the offense is committed with brutality, then a heavier sentence will be imposed upon the offender. If it shows that it comes with brutality, killing people with machine guns, killing people with sharp samurai or anything that is very brutal or something that is very dangerous, the nature of the weapon is to kill people, therefore the sentence will be heavier on part of the accused. The next one is the prevalence or rampancy of the offense. In the case of public prosecutor against Tan Aeng Hock, the court will give a heavier sentence to deter such offences for the benefit of the public. Therefore, in order the court to impose a punishment on part of the offender, the court have to look whether this particular thing will deter other people, the public, from doing this offense. For instance, let's speak about drug offense, 39B. Then the second one is the kidnapping for ransom, rape, and then robbery, theft, housebreaking, and firearms. So, the prevalence or rampancy of the offense, for example, the murder as well, under 302 of Penal Code. And now we have to look at the previous conviction or bad records. So, in the case of PP against Jafar bin Daud, the court will consider whether the offense committed previously has the same nature with the presently charged. So the court will look whether the offense that he had committed before and currently being charged now is having the same nature. So the purpose is to look at the factor of deterrent. Is there any deterrent effect on part of the punishment that had been given beforehand? So if the court feels like it is needed to be imposed for the interest of justice, therefore deterrent sentence shall be passed. Now we have to look upon the position or status of the offender. The position of the offender might affect the punishment that will be imposed upon them. Second one, the different position is equivalent to different behavior as well as different punishment. So different people with different status have different behavior, as well as the court will take into consideration this particular factor, this particular matter in assessing the punishment towards them. So in the case of PP against Khairuddin, a person who holds a strong position can be imposed with a heavier sentence, as they are not supposed to act in such way. Alright, and now we look upon the case of Tan Sri Abdul Rahim bin Muhammad Noor against PP. It shows that this particular case shows that higher position comes with higher responsibility. Alright, any irrelevant misconduct of offense will result to severe punishment as it should. In this case, the police shall be the role model, because in this Tan Sri Abdul Rahim case, the police shall be the role model towards the other staff, towards the lower position of police. Therefore, he has this position to act in the best way as he could, because everyone look at his position as because he has a good position to be looked upon too. I guess that's all from me today. Thank you so much, and Assalamualaikum.